the appellant. I assume you reserved any time for rebuttal?
Yes, Your Honor. We reserve 2 minutes for rebuttal.
Okay. In case you may proceed.
Okay. Thank you, Your Honor. If I may just have 1 moment.
Go right ahead.
May it please the court. My name is Matthew McClanahan, proudly appearing before this court on behalf of the appellant, Cumberland Point Condominium Owners Association. Your Honors, we raise 4 points on appeal, and we respond to one of the issues that the appellee in this case raises in regards to its attorney's fees in the matter before the court. We begin with the first issue, which is whether the trial court erred in imposing upon Cumberland Point a duty to remit dues for each condominium in Cumberland Point Condominium when there is no clear contractual duty to do so in the restrictive covenants. As this court is well aware, restrictive covenants are not favored in the state of Tennessee, and they are viewed and interpreted under typical contract principles with this court. The central tenets of contract construction is that the intent of the contracting parties at the time of executing the agreement should govern, and it should be limited to the 4 corners of the document. In the plaintiff's reply brief, it outlines 6 provisions that it views as being pertinent to this appeal. I would quote from those restrictive covenants that it talks in depth about the individuals and gives those definitions. The term person is defined as shall mean an individual, firm, corporation, partnership, association, trust, or any other legal entity or combination thereof. The term community club before the restrictive covenants means the Cumberland Gardens Community Club, which is the name that was later adopted by Renegade Mountain Community Club after it was incorporated in 1972. This court is probably somewhat familiar with the long and tortured history of Renegade Mountain Community Club. There have been 2 cases before this honorable court prior to this matter. As it relates to the definition of unit owners within the restrictive covenants, it says specifically, in addition to the assessment of the association, again, association meaning the Cumberland Point, the unit owners must pay dues to the Cumberland Gardens Community Club for their membership in the community club. Covenants furthermore say that the community club shall have all the powers set out in its articles of incorporation and all other powers that belong to it by operation of law, including, but not limited to, the power to levy annual dues against each member of the community club. The clear and express intent of the parties when these documents were drafted was for the community club, the HOA, to be the entity that would assess dues against a unit owner that did not remit his or her HOA dues to the community club or HOA, and that the HOA reserves those rights to prosecute and to place liens against that individual. To now make this condominium owners association stand good for each and every condominium on Renegade Mountain would be a clear departure from the intent of the parties and would create an additional contractual duty that would hamstring this small nonprofit condominium owners association and would also create a slippery slope for this court.
Well, I have some factual questions, and I'm sure this will probably get answered when I delve into the record a little more thoroughly, but the unit owners are the owners of the individual condominium units in Cumberland Point.
Yes, Your Honor.
Are the unit owners, they're members of Cumberland Point?
Yes, Your Honor.
Are the unit owners also members of what I will call Renegade Mountain, which would encompass the community club in whatever form it has been or was in? Are they also members of that?
That is also a question before the court. So there's also an issue of standing that is presented before this court of whether or not this Renegade Mountain that is the plaintiff in this case, whether it is the actual heir to that Renegade Mountain Community Club.
Putting that aside, whatever entity that is and whether it's valid or not, are they supposed to be members of it?
Yes, Your Honor. There would be overlapping membership in those 2 entities.
And so is Renegade Mountain responsible for collecting dues of the unit owners?
Yes, Your Honor.
That's in the covenants and declarations.
That is our belief.
Is Renegade Mountain also responsible for collecting dues directly from Cumberland Point as an entity? Or is it just the individual unit owners?
Just those individual unit owners. They would only be responsible from collecting from Cumberland Point to the extent that Cumberland Point owned units or owned
Okay.
property on Renegade
Okay.
Mountain.
Do those unit members also owe dues directly to Cumberland Point?
Yes, Your Honor.
So they have two different sets of dues that they owe?
Yes, Your Honor.
Okay. Historically, how have the unit owners paid their dues? Have they done them separately to each unit, or have they done them one to Cumberland Point and Cumberland Point remits to Renegade Mountain?
Unfortunately, due to the long history of litigation on Renegade Mountain, there has not been a firm set of standards that have existed going back from the incorporation in 1987 to the current date. There were periods of time where they were individual unit owners, and some did remit both their dues to Cumberland Point in addition to their Renegade Mountain dues. There would be instances where they would just remit one or the other. The Cumberland Point was in the position where, due to this litigation and being up on appeal for twice, they basically withheld the payment of those dues, kept those dues, because there were two boards that were fighting it out. There was the owners board that the court termed, and also the developers board. So there's not been a confined and understandable long history of track record for this court to review as it relates to that, just because of the long history of litigation in this case.
Okay.
Related, again, we continue to look at this, and we believe that there are some exemptions that were contemplated in these restrictive covenants that we make mention of. Again, when we think about the reason for the collection of dues by the HOA, whatever entity that is, that it relates specifically to the idea that it's going to be a way for them to bear the common expenses. We think about typical infrastructure that's with any planned subdivision and those things that occur there too. And the restrictive covenants contemplate that as well, including a discussion about a sewer system that would provide an exemption for individuals who were to be able to have that.
Okay, help me understand the sewer system argument a little bit better. Are you saying that because there is a sewer system on the property, no matter where it lays on the property, if it's within the confines of Cumberland Point, that in and of itself exempts Cumberland Point from any dues? It exempts unit owners from individual dues?
Well, in the case before this court, the individual unit owners were not sued. It was just Cumberland Point.
Right.
So our argument is because Cumberland Point is the one who outlaid the monies for this and has that unit contained within their bounds and meets, that therefore the Cumberland Point should be exempted from that, because they're the ones that had that capital outlay. And that's what the idea was. The restrictive covenant says that, in relevant part, the water and sewer systems property shall be exempt from assessments, charge, and any lien created herein.
Were there water and utility systems on the property when the units were created in 1987?
To answer your question, I don't know, Your Honor. But I can
Well,
say
presumably they got water from somewhere.
they did eventually obviously get utilities. However, then the transcript would show this, that it's been a difficult circumstance for them to be able to have utilities on the mountain due to the topographical features there. And the septic and sewer systems, as well as delivery of water, has been an issue in the previous litigation, and as well as one that had beleaguered Renegade Mountain for a number of years. So this benefits Cumberland Point residents, who also, as the courts mentioned earlier, are also residents of Renegade Mountain. And that's why it was provided for in these restrictive covenants that go back all the way to 1972. Again, contract law in the state of Tennessee allows for competent parties to be able to strike their own bargains, to make determinations of what they would want to do. The courts don't necessarily concern themselves with whether or not it's a good bargain or a bad bargain, but give the plain meaning of the intent that's written there within those documents.
Does Cumberland Point as an entity own any units?
At this time, Your Honor, it is my understanding that they do not.
What
at
about
this
during
point.
the period of time that Renegade Mountain was suing for? Did they own any of the units?
I'm not certain, Your Honor. I don't believe so, Your Honor. I knew that they do own a lot. Cumberland Point owns, I believe it's an undeveloped lot that they would have, or the area that surrounds those units. But
So
I do not believe that they owned a unit themselves.
Does Cumberland Point remit dues to Renegade Mountain for that lot?
They have, Your Honor, but that was prior to the construction of the sewer system, which we think gives them an exemption in this case. And there's a question of whether or not they would be required to pay dues for that lot.
Does the sewer system just run through the Cumberland Point Homeowner Association property? Does it cover other parts?
It impacts just the Cumberland Point owners, Your Honor, as it relates there, who are also obviously residents on Renegade Mountain. In short, Your Honor, as my time comes to a close, I want to make mention of our two remaining issues. One is the court denied a continuance in this matter. Obviously, wildfires are within our current consciousness because of the terrible tragedies that are happening in Los Angeles and that the firefighters are battling there. Unfortunately, Renegade Mountain was subject to a similar wildfire just a week before the trial that was to be had. Our position is we should have been allowed some time to, obviously, just going through such a difficult and harrowing event as a wildfire, to be able to push back a trial, to provide adequately, to make sure our witnesses are provided for adequately, to be able to have a trial on the merits of this case. That was denied by the trial court.
Was there some witnesses that were unable to testify due to the wildfire?
There were not any witnesses, no, Your Honor. It was more of a impact of, obviously, it shortened the duration of time that we could prepare for trial, because obviously they're trying to deal with the immediate ramifications of this serious natural disaster. And I would posit for this court, too, that there's an inherent psychological impact of that, where people need time to collect themselves and be able to focus on a court. Whenever a wildfire is raging around your home, it's hard to have an idea about anything else.
So if there wasn't any witnesses that impacted, was there counsel that was impacted in some way by the wildfires?
Well, I represented them at the trial court level as well, and there was it shortened the amount of time that we prepared for, because obviously they were trying to tend to the needs of the community there, and it impacted our ability to meet and confer and provide in witness preparation.
But it's hard, though. This case is about, it's collection of money, right?
Certainly.
And interpretation of documents. So I'm not quite following what sort of prep might have been interrupted as a result of the wildfire.
More so just time, again, just going over those documents. It's somewhat voluminous, and having those discussions about what the documents say and where, and what opposing counsel would potentially cross-examine a witness for.
But those are all questions of law.
There's largely, but there's also some questions of fact as it relates to the accounting and why certain items were delineated within the bookkeeping and those types of issues that would be relevant for.
Does Cumberland Point have a separate CC&R in addition to what Renegade Mountain has? It
is an interwoven. To answer your question, Your Honor, yes, there is, but they are all originating from they all flow from that same declaration, covenants, and restrictions. So they work within one another. There's a supplement that is specific to Cumberland Point, but it works in theory hand in glove with these overriding restrictive covenants that impact Renegade Mountain as a whole. Your Honors, in conclusion, we think that the court made a reversible error in this case, and therefore that the case should be overturned. Thank you.
Thank you, sir. You have your rebuttal time. Yes, sir.
Good afternoon. May it please the court, my name is Jack Atkins, and I represent the Appalachia Renegade Mountain Community Club. My client was the plaintiff at the trial below, and Mr. McClanahan's client was the defendant below. I will not be reserving any time for rebuttal.
That's not the practice that you would be able to do so anyway, but go right ahead.
Thanks, sir. Renegade Mountain is a planned residential community in Cumberland County. Its original declaration of restrictive covenants was filed in 1972. It consists of single-family detached homes as well as attached homes such as condominiums. There's over 1,300 properties in the development. Cumberland Point Condominiums is a condominium development that was added to Renegade Mountain Development in 1987 by a supplemental declaration. That is Exhibit 18 in the appellate record. It was drafted by the developer at the time and joined by both the plaintiff and the defendant, and those parties agreed to the terms of the supplemental declaration. Cumberland Point was made subject to the 1972 declaration as well. Renegade Mountain Community Club is the owners association for both single-family detached homes on the development as well as the condominium owners. Cumberland Point Condominiums Property Owners Association, the defendant, is the operating entity for Cumberland Point Condominiums. Also, as such, the defendant is responsible for paying the common expenses for the condominium development. In response to the defendant's issue number one, the plaintiff responds that the defendant does in fact have the duty to pay plaintiff dues for each condominium. The 1987 supplemental declaration expressly provides that each condo owner is a member of the plaintiff organization and also owes dues to the plaintiff organization. It also expressly states that the dues that are owed to the plaintiff are part of the common expenses of Cumberland Point condominiums. That document, the 87 supplemental declaration, also requires the defendant to collect the dues owed the plaintiff from the condo owners. To assist the defendant in that duty, the 87 supplemental declaration also authorizes the defendant to assess condo owners amounts necessary to meet the common expenses of the condominium development. Also, the 87 supplemental declaration authorizes the defendant to enforce claims and liens against the condo owners for dues owed third parties, which would include the plaintiff. Issue one, as framed by the defendant, states that its duty to pay for all condos in the development is not clearly stated in the 1987 supplemental declaration. I submit to you that the provisions I've stated so far are unambiguous and have not been challenged in any way by the defendant. And by taking all of those terms together, at the very least, it's implied that the defendant has this duty. If the terms are ambiguous or indefinite, then the doctrine of practical construction would apply to impose this duty upon the defendant. Testimony at trial by both the president for the defendant and president for the plaintiff indicated that at least at the time frame of 2016 and prior to that for many, many years, the defendant paid dues to the plaintiff for each condominium on a monthly basis. This practice stopped approximately in 2016 so that the defendant began to use the dues that were owed to the plaintiff for their own purpose. And their primary need at that point, as stated by their president, was 15 years of accumulated deferred maintenance of their own development.
during the period of time that the landowners, the homeowners, that they actually paid to the defendant these dues, and the defendant actually used these dues without
Yes,
taking
sir.
them from
Gloria Hutcherson testified at trial. She owned a condominium all the way back to 1988, near the very beginning of the project. And she testified the practice was that each month she paid, along with the common expenses charged by the defendant, the dues that were owed to the plaintiff. She paid all of that in one lump sum to the defendant. And the defendant was then obligated to parcel out the amount owed the plaintiff and send that to them. According to the testimony of both presidents of the organizations, that's what happened from 2016 going back, but then it stopped sometime after 2016.
So before 2016, will the evidence show that if a unit owner failed to remit the owed dues that were owed to the plaintiff, if they failed to remit them to the defendant for payment to the plaintiff, would the defendant nonetheless make that payment to the plaintiff?
The evidence is that the dues that were paid to the plaintiff was the amount of the annual assessment divided by 12 for each condominium unit. And there was no testimony of what happened if one of the unit owners did not pay that. There was no testimony to that effect.
I mean, I can see as a practical, from a practical standpoint, it's easier just to sue the corporate entity here. But it does sound like the CC&Rs provide the unit owners have the liability. I mean, you talked about an implied obligation to pay. I mean, why wouldn't, I mean, how many unit owners are we talking about for the condominiums?
It started out with 84 units, and the fires have reduced it down to 64 units.
But why wouldn't you name the unit owners that has the responsibility for payments under the CC&R?
Well, as I mentioned earlier, the 87 supplemental declaration submitted and made the condominium project subject to the 1972 declaration. And in the 1972 declaration is where the plaintiff is stated to have the power to assess all its members' dues and to collect those either by suit or through the enforcement of a lien.
But you said all members, and would the Cumberland Point Condominium Property Owners Association be considered a member? I would think the unit owners would be considered members.
The unit owners would be considered the members, yes.
Okay. I mean, what I gather from all this is that when the CC&Rs were initially recorded in 72, there was really no contemplation at all of a condominium complex. Rather, it was all single-family detached is what was envisioned in 72. And then in 87, they engrafted a condominium association, which really didn't quite fit the CC&Rs that were adopted in 72.
Actually, the 1972 declaration does contemplate the possibility of condominiums in the development, in the definitions of members. It includes both lot owners and owners of living units. Living units are defined basically as being the multifamily attached dwellings that would be a condominium. So I believe the original developer did contemplate that at some time, but it didn't happen until 1987.
So if you were pointing us to one provision in the 1987 supplemental declaration, you said, okay, that's what you can put your finger on that says that imposed liability on Cumberland Point, what provision would that be?
that the dues owed the plaintiff are classified as a common expense of the condominium association. Another example of a common expense of the condominium association are the insurance premiums that they pay to insure their buildings. That is something that is owed regardless of what the individual condominium owners do in terms of fulfilling their due obligations. So the classification of these dues to the plaintiff as common expenses is significant. It removes it from being solely an obligation just from the defendant to the plaintiff. In the articles of incorporation for the defendant, which is attached to the 87 supplemental declaration, the articles of incorporation as well as their bylaws state that the defendant is responsible to pay the common expenses of the development.
So it says Cumberland Point is responsible to pay, not unit owners or not members.
It is a duty that the unit owners are subject to assessment by the plaintiff and owe dues. But that expense is bundled into the common expenses for the condominium project.
Judge Davis asked a question earlier that I don't know that I understood the response to about who bared the loss if you had a condo unit owner that did not pay their share of the assessment. Who bared that loss? Who bears that loss?
The 1987 supplemental declaration gives the defendant authority to to enforce the claim for the plaintiff and the plaintiff's lien against their unit owners.
But wouldn't Renegade Mountain also have a lien claim under the original
They
72?
do.
And so that would have to be, because it's a condominium project, it would have to be a lien against the entire project.
The 72 declaration empowers plaintiff to have a lien and the power to sue directly to collect those. And that is what the 87 supplemental declaration states: the defendant has the authority to enforce on behalf of the plaintiff.
Are you saying that by virtue of the 87 supplement, it took that authority away from the plaintiff and gave it to the defendant such that the plaintiff no longer has it, or they both have it?
They both have it. It did
Okay.
not take it away. I believe that the 1987 supplemental declaration, when drafted by the developer wisely foresaw the possibility of conflict between the parties, and the plaintiff should not be left without its own power to collect these dues should the defendant fail to do so. And of course, this case is a good example of what has happened, so that the plaintiff would not be left entirely at the mercy of the defendant. Looks like my time's up. Thank you.
Before you start in your rebuttal, the trial judge made a ruling on credibility against your client in this case. Was that based upon one specific action, or was that based upon the entire nature of the case?
Your Honor, I don't really know where that came from. I've had the pleasure of knowing David Carter for a number of years now, and I find him to be exceedingly credible. He's a veteran of the United States military, and I don't know that, it's my understanding from reviewing the record of the court that he doesn't make any factual findings of why he determined that, made that credibility statement, and it's one that we strongly object to, and we don't understand why the court made that ruling. I don't know why that was, but it was one that was in error, certainly. It may please the court, in my rebuttal, the counsel for the plaintiff, appellee, makes mention of the smoking gun, and Your Honors asked him if you were to point to one specific provision, what would it be? He talks about the common expenses. This is what it says, to quote it. However, the common expenses of the condominium project shall be shared by the unit owners, again, a defined term, not this defendant, in accordance with their respective interest in the common areas and common surplus as defined in Article 7 and Article 9. Again,
What article of the 87 does that appear in?
Your Honor, I apologize. It's Exhibit 18 of the record, so is where that can be found. Again, these are expenses of the unit owners, not the association. If it wasn't so, then it would be that way. He does make mention of the fact that there is a provision that says the association, talking about Cumberland Point, acting through its board of directors, may enforce its claim and lien rights for the recovery of unpaid assessments owed to the developer, any unit owner or group of unit owners. However, there is a world of difference in may and shall. In summation, and just to close, again, this court should look at the standing issue that was raised at trial, that the issue is that this homeowners association that is the plaintiff in this cause is not the same organization that was in existence in 1972. Rather, it is that putative owners board that existed and occurred. You can look at the timeline of events that is as of the record of this court. When this action was brought, that originally contemplated organization simply ceased to exist, that there was no standing for them to bring this suit before this court. Your Honor, we believe that reversible error has been made, that there should be a limitation of the awards in this case, and that the trial court's determination, especially when it comes to the payment of dues that were not remitted at any time to Cumberland Point, for them to have to stand good for those dues and pay money that has not been paid to them, to pay money that they don't have, goes against clear legal principles, the contract that the party's into, and equity as well. Therefore, it should be reversed. Thank you.
Thank you. I want to thank both of the parties for your presentation. Your case has now been submitted to this court for a resolution. You should receive our opinion and ruling within a reasonable period of time. Okay. Thank you both, and you both may be excused.